To get the alimony tax deduction, there are 7 legal requirements under Section 71 of the Tax Code. In Chapter 3 of my book, Frumkes and Verts on Divorce Taxation, we describe the 7 conditions for preserving the alimony tax deduction with case law and examples. If any of the 7 conditions are not met, the payments will not qualify as alimony under federal tax law. On the other hand, if all 7 requirements are met, the payer may deduct the alimony payments from taxable income on the federal income tax return, and the recipient is required to declare the same amount as taxable income. To meet these 7 federal tax law requirements, number 1, there must be a written agreement or court order. In the tax code, a written settlement agreement or court order is also called a divorce instrument. An oral agreement is not a divorce instrument. Payments that are made before the divorce instrument is signed cannot be tax deductible as alimony, even if the instrument has a retroactive effect. Also, any payments that are not required by the instrument cannot be tax deducted. For instance, if someone voluntarily pays more than required by a divorce instrument or continues to pay after the obligation expires, those payments are not tax deductible. A divorce instrument is a written settlement agreement or a decree in divorce or a decree of legal separation or property distribution. Number 2, the alimony obligation must be paid in cash. However, a check or bank transfer will also work. Number 3, the payor and the recipient must file separate tax returns. If the spouse who is paying alimony files a joint return with the spouse who is receiving it, their joint return would include the alimony tax deduction and also the taxable alimony income. They would wash each other out. So if you plan to file a joint return while paying alimony, you should understand that you will not get the alimony tax deduction. Number 4, the alimony obligation must terminate if the recipient dies. Alimony is intended as a source of income for the recipient, so it has to end when the recipient dies. It does not have to end when the payor dies. But since dead people don't file tax returns, there wouldn't be an alimony deduction. Number 5, this obligation cannot be front-loaded so that most of the alimony is paid in the first 2 post-separation calendar years. The tax code contains a penalty called alimony recapture, which is so complex I'll be posting a separate article just about that. Number 6, the alimony and recipient must live in separate households except for temporary support orders. If the payor and alimony recipient could live together, they could continue to function as a couple and get tax benefits that no other couples would have. The IRS has disallowed this. Number 7, the alimony obligation must not be confused with child support. This is another complex topic. If you have children and want to preserve the alimony tax deduction, read my articles on alimony and child support. Those are the 7 legal requirements for crafting an alimony obligation that is tax deductible. Some of them are more detailed than I've described here, but my book contains additional details. If the payor claims an alimony tax deduction that doesn't match the alimony income reported by the recipient, both parties can be audited. That's when the IRS will check to be sure that all 7 legal conditions are met. When you settle a divorce case or go to trial, you have to be sure that the settlement agreement or court order meets these legal requirements. For family law help in Western Pennsylvania, call me. I'm Brian Verts, and for more than 25 years, I've represented all kinds of people with complicated child support and divorce issues. My law firm is a powerful team of lawyers dedicated to family law. In Pittsburgh and Western Pennsylvania, call me at 412-471-9000.